This is from LexisNexis, 2019. They said the last time the laws were amended was 2017. So these are up-to-date interpretation, my interpretation of the strict liability dog bite law of Colorado, CRS 18-9-204.5. 1A. Dangerous dogs are a serious and widespread threat to the safety and welfare of citizens throughout the state because of the number and the serious nature of attacks by such dogs. 1B. Regulation and control of dangerous dogs is a matter of statewide concern, therefore superseding home rule. 2B. Dangerous dog means any dog that, 1, causes injury or death. So if you have a dangerous dog, you're the one guilty of the crime. The owner is. The dog may be punished, especially if they kill a person, right? So not only will the dog be punished, but the owner of the dog will be punished. And that actually makes more sense. I mean, you have infinite, empathy for animals. They're just being themselves, right? They just act like animals. But you're the owner, so therefore, if that animal does anything, criminal, injures, serious bodily injury, regular injury, a bite, any kind of assault or permanent disfiguration or death or murder, the owner, what ought to be, is that the dog that commits the crime, it's like as if the owner did it him or herself. So if a dog commits a crime, the dog is an extension of that person, of the owner, and therefore they should, be charged with the crime. This is a strict liability dog bite law. Dogs can't bite people, humans, persons, or animals. They can't bite pets, and they can't injure pets or livestock, or wild animals, for that matter, or the nest of wild animals. So 3A says that anybody who has a dangerous dog, therefore a dog who has committed an injury or a murder, is guilty of a crime. This is important to understand. So I'm going to break down the misdemeanors, okay? So if a dog injures a human being, if a dog goes up and bites, little Johnny or little Sally in the ankle, then that dog is guilty of committing bodily injury. Serious bodily injury is like permanent disfiguration, near-death experience, so a vicious and heinous attack. That's a serious bodily injury crime. These are important because bodily injury is different than serious bodily injury. Serious bodily injury has a lot more punishment. They're both strict liability laws, so there's actually a shit ton of exceptions to this law, and I'll get to that at the end, which is where they put it in the law, so I'm just doing it in order by the way that they wrote it, okay? Shit. So, if your cat goes out and scratches the neighbor's kid next door, that is a Class 3 misdemeanor. If your cat, again, even after the charges have been filed and the owner has been convicted of Class 3 misdemeanor, if there's a second time that it happens, then that's a Class 2 misdemeanor. It goes up a level, right? Felony is above misdemeanor, just like mortal sin is above venial sin. So the felonies are the big crimes. These are big evils in society. So bodily injury, violence, assault, murder, yes, these are very much, not only are they immoral, but they're also very illegal. So maybe if people don't listen to morality, maybe they'll listen to the law. So the way it breaks down, if the cat scratches, or a dog bites the mailman, 1 time, Class 3 misdemeanor, 2 times, Class 2 misdemeanor. Also, if a cat scratches your cat, if there's a dog that bites your parrot, or your cow, or, your pig, whatever you have, if a dog bites a human or a pet or livestock, It's the exact same. Bodily injury is a Class 3 misdemeanor the first time, and bodily injury for the second time, a bodily injury incident that happens for a second time is a Class 2 misdemeanor. And it says that it shall be mandatory, right? It shall be mandatory, meaning that if it actually goes against the human, the minimum fine is paid. So that's actually good for the human. That's something the human has that the dog does not have. If you have a pet dog and it gets bitten, then it's not specified that they must pay. I think they do say restitution later on, but here it's sitting there saying that the minimum fine specified in Section 18-1.3-501, the minimum fine shall be enacted and Class 2 misdemeanor shall be mandatory. You cannot get past. Your dog bit the mailman 2 times? 2 times this month, huh? Okay, well, you're a criminal. I'm going to charge you with this crime. You're going to get locked up. You better have bail money. You better show up to court. And this is a strict liability law. So these are, the extreme cases, a lot of exceptions. But essentially, since it's a strict liability law, when it happens, when it can be proved, when it can be proven that bodily injury or murder, if a dog caused murder or serious bodily injury, immediately criminal charges are filed without a doubt, without question, and restitution is paid to the victims. They don't have to go to civil court. They don't have to sue them. Nope. Your dog bit somebody? Well, you're a criminal. You get charged with the crime. And you pay for the medical expenses and, whatever. If it's a death, how much money are you going to put on a death? Was that $3.5 million? Is that what a death is worth? So, automatically, because it's a strict liability law in cases of these extreme examples, automatically the state government says, fuck you. But there's a lot of exceptions, so these are the most extreme cases, right? So, violence and murder. But I guess dogs could bark at you. I guess dogs could pee on you. I don't know if that's illegal. Dogs could take a shit on your porch. It doesn't cover those incidents. Let's put it that way. So if there's serious bodily injury, the first time is a Class 1 misdemeanor at the very top. And if it's a second time, then it's a Class 6 felony. So serious bodily injury, which is permanent disfiguration, near death, a vicious and heinous attack. First time is the very top, the worst misdemeanor, and then the second, I guess, is the bottom, felony. Death, if a dog murders a human, that's a Class 5 felony. And that's actually kind of crazy. It doesn't say, if it happens a second time, it doesn't mention, I think immediately, if there's a death, it's just assumed the dog is going to be put down. And they do euthanize dogs, violent, vicious dogs who've attacked it. I guess it determines the case. But murder, no question, the dog gets put down. Now, what I find interesting about the death being a Class 5 felony, so Class 6 is, probably on the bottom. It's a range. I don't know if there's anything lower than Class 6. So 1 is the worst, then 2, then 3. So 6 is right here, and then 5 is right here, right? 6, 5. So, Class 5 felony. So if you have a dog that goes out and murders something else, that dog's going to be put to death, but the owner isn't charged with the same crime. If a human, did that to another human, if a human took the life of another person, that's Class 1 felony, right? You have to determine what kind of felony is it. Is it manslaughter, which is a horrendous name for a lesser charge, or is it a first-degree murder, second-degree murder? Was it premeditated? Was it intentional? Was it the heat of the moment? Did you plan it all out? So there's ranges of crimes, right? If someone steals $1 from you versus someone stealing $5,000. it's different, right? That's different. So I find it amazing that the dog only gets a Class 5 felony, or the owner only gets a Class 5 felony if they murder, because if that dog is the extension of the owner, then that means if that dog murdered, then that means that owner murdered. So there's, it's a felony, but a Class 5 felony. I don't know. It just, I don't like it, but them's the rules. That's the rules. That's how it is, right? So a dog commits a murder, it's going to be put to death, but their owner is going to get a Class 5 felony, not as if they did it, but as if their dog did it, so maybe there's some justification there. Any owner who violates A of this subsection 3, whose dog inflicts bodily injury upon another person, commits a Class 3 misdemeanor. I already said that, but essentially if you have a dangerous dog, if your dog has committed an injury, then you're a criminal. Now, there's many affirmative defenses, and this is listed in the law. This is listed in the same Title 18-9-204.5. And it says there's 5 defenses, and then there's like a couple more down here. So, and then other laws kind of validate and repeat and crystallize to make it, more specific. But this is just how this section 18-9-204.5. That's how this section works. So the first affirmative defense, which is 3.E.III.B.IV.H.I.A, and then there's B, C, D, and E. So A, if the dog was at large and astray and entered upon the property of the owner and the attack began, but maybe it didn't end there, that's okay. That's an affirmative defense, okay? So if you have a dog and it's running out there because it got loose, or you let it run away and then it just stays away, so therefore it ran away and it's estrayed, estranged or just a stray. Basically it used to be owned, but now it's a stray dog. If it used to be owned by the thing and it runs away and then it enters your property and attacks you, whether it stays there or goes to another property, that's okay. That's an affirmative defense. So if one of your dogs, attacks a pedestrian, that's an excuse you could use. Oh, the dog the dog ran away a month ago. I didn't even know it came back. B, dangerous dog was defending itself from another animal, or they're defending their owner. That's reasonable. At the time of the attack by a dangerous dog that committed injury or death of a person, the victim was committing or about to commit a criminal offense. Not a petty offense, but a criminal offense. So, what's the difference between a petty offense and a criminal offense? Is trespassing petty? I think if they're trespassing, you might get bitten by the dog. But trespassing, is that petty? Jaywalking is petty, right? But trespassing, that's like an invasion. But that's the distinction it makes. If the victim was about to commit a criminal offense against the dog's owner, even if the attack didn't occur on the owner's property. So, if it's after a criminal, right? A criminal's about to punch or hurt somebody or rob somebody or, rape somebody. If a dog attacks that person against the dog's owner, and the dog defends the owner from the rape or the murder or the stealing or the violence, then that's okay. And that's reasonable too. I need to understand petty versus criminal offenses. I understand in my mind that, some crimes are less than the other, but what specifically is a petty offense in Colorado versus a criminal offense? Colorado has the longest state constitution in the United States, so the laws just go on and on and on. This is, again, the fourth one, right, A, B, C, D, E of CRS 18-9-204.5.3.E.III.B.IV.H.I.D. So if you were doing like notes, that would be like off your page. You couldn't even write it in your notebook. So D is if at the time of the attack by a dangerous dog which causes injury to or the death of a person, the victim was committing or attempted to commit a criminal offense, not a petty offense, against a person on the owner's property or the property itself, and the attack began but didn't necessarily end on that property. So again, if the victim was committing or attempted to commit a criminal offense against not you, the owner, but one of your friends, a person on the owner's property, one of your friends or one of your family, or the property itself. So if the victim, so-called victim of the dog bite, was committing a crime or criminal offense against a person on the owner's property or the property itself, and whether or not the attack ended on that property, but it began on that property, then that's okay too. So dogs can bite people who are about to commit criminal offenses, not petty offenses. Whether it's against the dog's owner, whether it's against the owner's property, or whether it's against the owner's friends or family or guest on their property. Last but not least, E. I'm getting thirsty.